Hey everybody, News Now Wyoming here. Let's back that microphone away a little bit. News Now Wyoming here, bringing another episode where we are looking at the lawsuit between Legalize drugs and Schrodinger's cat. We went off on a tangent yesterday, fact-finding some of this information. Because I only looked in one court, I can't say whether or not some of what he says here that it resulted in financial settlements. I could not find any that resulted in financial settlements, but that does not mean that it's not true. All of his cases that have been filed in his own circuit court have been dismissed. That except for two that have been 2 or 3 that are just so new that they haven't been dismissed yet. And I am going to do some videos on those because I did download them and read them, and they were also hilarious. So I think there's good laughter to be had in those, so we will be covering those as well. I'm thinking I'm going to make a series on just legalized drugs, the convicted felon on that. So here we go. Let's look at this. Constitutional rights violations captured in the videos featured on Mark Stout's YouTube channel have resulted in other pending federal civil rights lawsuits. Correct. The videos featured on Mark Stout's YouTube channel have served as evidence in criminal judge and jury trials whereby defendants, including Mark Stout, were found not guilty as a result of the exculpatory nature of the police misconduct captured in the videos. I don't know that. I will take that as at face value, but how is that relevant? How is any of this relevant, really, after like paragraph 2? Videos featured on his YouTube channel have served as evidence in criminal judge and jury trial, proving that the police lied about material facts concerning the elements. Again, not relevant. Were we crossing through? Oh, we were going to cross through irrelevant stuff, but whatever. Videos featured on his channel sometimes served as the only pieces of evidence in judge and jury trials, proving that a police officer lied about material facts concerning the elements. Okay. Again, relevance. Videos featured on his YouTube channel served as evidence to impeach police officers during trial. Again, relevance. Videos featured on his YouTube channel has served as evidence to substantiate formal department complaints against police officers that were deemed founded by the departments. Again, relevance. Police misconduct in the videos featured on Mark Stout's YouTube channel has resulted in police officers being reprimanded, demoted, and or fired. Okay. Relevant, but okay. The purpose of his YouTube channel is to advance and promote the First Amendment right to film the police and police citizens encounters. Okay, great. The purpose of his YouTube channel is to advance and promote the Bill of Rights and the Constitution. Purpose of his activism is to familiarize police presence with and adjust police presence to the presence of civil rights activists and cameras. Worthy goal, but irrelevant to this lawsuit. Purpose of his YouTube channel is to demonstrate to viewers not only how to exercise their constitutional rights during police and citizen encounters, but also how to create and use police and citizen encounters to advance and further constitutional rights for themselves and everyone else. Again, very I can stand behind that purpose, but how is that relevant to this lawsuit? The purpose of his YouTube channel is to educate and inspire others to become civil rights activists in the wake of the proliferation of police attempts to criminalize camera people who film the police and police citizen encounters. Again, how is that relevant to the facts of this case? That's what we're under, right? We're under the facts. Yes, we are. Okay, I thought so. Does not feature videos of instances of casual police presence, police non-interaction, or casual police citizen encounters. How, again, relevance. Purpose of Mark Stout's YouTube channel is to bring awareness and attention to police power, pride, and ego, and to the disturbing effects and consequences thereof. And that's something I speak on all the time, right? That those are what the legitimate lawsuits against police officers that I cover. That's exactly what I speak out against, is police contempt. They arrest you for contempt of police, not for any actual crime. So, worthy goals, but relevance to this lawsuit. He supports the institution of law enforcement, but Mark Stout also supports institutional law enforcement reform. Great, worthy goal. I am behind law enforcement reform. Mark Stout is not against the police, but he is against the police state. Okay? Again, relevance. He knows and believes that most cops have pure motives most of the time. Time and again, we see shining examples of gracious acts of valor displayed by the police. However, cops who conduct themselves lawfully are either protecting or not betraying the cops who conduct themselves unlawfully. Maybe this is because every single cop at some point participates in the unlawful conduct. Facts not in evidence, irrelevant to this lawsuit, unfounded. And I say stuff like this all the time on my YouTube channel too, right? Is when a bad cop is surrounded by good cops surrounding, allowing his bad behavior to continue, is there any such thing as a good cop? I say that type of stuff too, but how is that relevant to this lawsuit against a private individual? Mark Stout does not want to believe that, but Mark Stout does not know either way. Again, relevance to this lawsuit. And a 28.1, but no... okay. Mark Stout's YouTube channel and channel videos have been shared by Pioneer Police accountability channels that have generated hundreds of thousands of subscribers and millions of views each. His videos have been featured on other police accountability channels that have generated millions of views on those and thousands of new legalized drug channel subscribers. His YouTube content has generated an overwhelming amount of articulate and thoughtful public support. Cliff Overby is also has a YouTube channel, and in 2015 named it Schrodinger's Cat. Cliff Overby's YouTube channel features videos of police brutality and civil rights violations that are praised and glorified by voiceovers spoken by Cliff Overby. Excuse me, I felt some sneezes coming on. Features videos of police brutality and civil rights violations that are praised and glorified by voiceovers spoken by Cliff Overby. His voiceovers contain language encouraging the police misconduct. So again, this is what's stated in the thing. I don't know whether or not. I haven't watched all of Schrodinger's Cat videos. I've never heard these types of voiceovers, but doesn't mean it isn't true. Mostly to the effect of beat him, tase him, mace him, shoot him. Don't talk back to the cops, idiot. You don't have rights, stupid. You have to do what the cops say. Dum dum. How dare you challenge a police state that keeps us safe, moron? And only the cops know the law, not you, jackwagon. The Constitution doesn't trump the police or state law, clown. And I don't know if those statements are true. Irrelevant to this case. His YouTube channel audience is mostly law enforcement, future law enforcement, retired law enforcement, family members of the above, and blind radical supporters of Back to Blue and Thin Blue Line far right-wing pro-law enforcement affiliations. Now, I like Schrodinger's Cat. Some of the stuff he says I agree with. Some of the stuff he says I don't agree with. I do watch his channel from time to time. I sure as hell don't fall into this, but he does say mostly, so. But, and I don't know who his audience is. I don't know who his audience is supposed to be. But again, how is that relevant to the case at hand? They openly, expressly, and unapologetically favors a police state over an American Constitution. So what? Let's pretend that is true. Let's pretend that what they are saying, what he states here, is true. Okay? That his audience openly and expressly and apologetically favors a police state over an American Constitution. What the hell does that matter? You are allowed your own First Amendment protections, and so are they. They are allowed their own opinions, just as anybody else is. So, this is prejudicial and is not relevant to the case. Cliff Overby, according to what he perceives as fair use, downloads videos of police misconduct and police brutality from police accountability channels before re-uploading the videos to his own channel. Now, what is fair use? And again, irrelevant to this lawsuit, but fair use is where you take a video put together by somebody else and you add your own commentary to it. Maybe you disagree, agree, but you add your own commentary. And there's multiple factors in there on what would factor into fair use. But downloading a video and putting your own commentary and laughing and obviously putting against a different audience. Now, keep in mind, he is correct here. So this actually, his channel audience openly, expressly, and unapologetically favors a police state over an American Constitution. So Schrodinger's cat audience is completely different than a First Amendment auditor's audience. Can we all agree on that? That they are intended for two completely different audiences? And one of the strong factors in fair use is whether or not their use of it took away from the original viewing of it. So if your intended audience is completely different, then it's fair use. I mean, everything I've ever seen posted by Schrodinger's cat, as far as the video itself, falls under fair use. But again, irrelevant to a defamation lawsuit. The police misconduct and police brutality in the videos that he downloads from police accountability channels has resulted in officer indictments, lawsuit settlements, officer firings, and not guilty verdicts and dismissals in criminal proceedings instituted against the victims of the police violence. Okay, relevance. In an example of this, he recently uploaded a video of an already viral encounter between the Keller, Texas police and two Latino men who were father and son. Keller, Texas is an 87% white community. He titled the video, "Son, this is not how you get arrested, hold my beer." A title suggesting that the father was dumber than the son for getting arrested for interfering with the son's arrest. In the video, the son was pulled over in his vehicle by the police. The father was close by, pulled his own vehicle over, stood on the sidewalk, and attempted to film his son's encounter with the police. And you guys, I've watched the original videos on this, and the police were very wrong in this. Again, I don't always agree with Schrodinger's cat. I don't agree with his views, but guess what? I don't have to. Neither does anybody else. The felony charges were later dismissed. The police department settled the father's and son's civil rights claims out of court, and the officers involved were demoted or otherwise reprimanded. All true, irrelevant. His video title, attempting to hijack the narrative of the incident, presented the father-son as criminals and instigators. Of course, Cliff Overby didn't mention in his video title, description, or voiceover that the father's and son's charges were dropped and the cops sued, or that the son's stop was itself questionable. That does not matter. That is irrelevant, isn't it? I mean, how is that relevant? You don't have to include that type of information in your video if you don't wish to. That would be compelling speech, which would also violate the First Amendment rights. So, you cannot tell somebody how to talk. Okay? And that's exactly what this stuff would do. But irrelevant. And I don't know when this video, when he did the voiceover, or when he produced it on his channel, if it was after the case was resolved or right when it was all released. I don't know. But irrelevant. However, the tidal wave of public opinion criticizing the police misconduct in the viral video had by that time overwhelmed Cliff Overby's desired narrative so much that even his YouTube audience retreated from praising, glorifying, and worshiping the police violence depicted in the video out of fear of being paraded around and exhibited by and to the court of public opinion as violent criminals. That'll be Exhibit 8, screenshot of the comment. Okay, so we'll make sure we look at that. Not long after Cliff Overby uploaded the father-son video and was unable unexpectedly to corrupt the narrative or the tidal wave of public opinion surrounding the incident, he uploaded a token video to his YouTube channel virtue signaling against police violence towards black or brown people and people of color. What the what's a token video? If I am wrong, I'm going to put it. If I do a video, record a video where I am completely wrong, I will upload a video after the fact and say, "Hey, I was wrong. Here's what I've learned since then." That's what's a token video. And again, I haven't seen his token video. I've never even seen Schrodinger's cat video on what he actually said during it. I mean, that doesn't matter. It's irrelevant to this lawsuit. It's irrelevant to anything that concerns me. He also downloaded a video of an already viral encounter between two white police officers and a black army officer and uploaded the video to his channel titling "Idiot Cop Does a Massive Dumb and Gets Fired." Okay. So, of course, the tidal wave of public opinion surrounding the encounter had already once again decided for Cliff Overby that his thin blue line, black the blue narrative was going to be second rate. Well, so yes, that is correct. He realizes, oh, this is a bad encounter, so I'm going to say this is a bad encounter. I mean, so obviously, Schrodinger's cat does not have a brick wall of no cops can do wrong. He does not have that in there, does he? Okay. In the video, the army officer was pulled over for not displaying license plates. It was later determined that his temporary plates were visible to the police officers before the stop. The army officer and his dog were maced in their vehicle for questioning the stop, and the army officer was dragged out of his driver's seat and threatened by police with violence if the army officer reported the incident to anyone. The officer was fired, sued, and is being investigated by the FBI. Relevance to this lawsuit. After all of that, he still couldn't help himself and just had to make a passing comment in his army officer video that even though Cliff Overby now agreed with the tidal wave of public opinion, the officer still shouldn't have questioned the cop. That is Cliff Overby's right to believe that. He can be wrong, he can be right, but that is his absolute right to believe that you shouldn't question police. That and Schrodinger cat has a very strong belief, and watching his videos, I don't want to put words in his mouth, but I take what he says as the place to question the police is not on the side of the road. The place to question the police is in the courtroom. I don't disagree with that. I disagree. I can't disagree or strongly agree with that either. I mean, facts change, right? Every circumstance is different. So I don't take a hard and fast, and I don't know if Cliff does either. But I mean, that's the overall view that I get from watching his content is the side of the road is not the time to question the police, which is a fair argument. However, as a testament to the paradoxical effect that the Army officer video places on the truth about his channel, the video last uploaded to his channel before the Army officer video depicts a stack of white police officers kneeling on top of a black civil rights activist's back and neck and suffocating, unfortunately not to death. The civil rights activist in the video was News Now Omaha. Okay. He recently uploaded a video to his channel depicting a white police officer shoving News Now Omaha head, neck, and back first down onto a cement sidewalk for filming too close to the officer. The incident is now the subject of a viral and now far-reaching scandal. The officer's body camera revealed to his superiors and to the public that NNO never raised a fist at the police officer like officer stated to justify shoving NNO. NNO, however, himself is also under scrutiny for the appearance that he may have participated in some kind of conspiracy to have the cops called on him. He is particularly vitriolic towards civil rights activists of color, augmenting the gravity of the viciousness of his attacks on them and other people of color also. Again, irrelevant to this charge, you are as white as can be, Mr. Stout, so how is this anything other than just irrelevant crap to try to get the court on in your favor? I mean, I would say that 90% of your lawsuits should be deleted from the record. Army officer video betrays itself to the engulfing catalog of videos on his channel depicting civil rights activists of color and not of color being subjected to praise, glorified, and worshipped police violence and police misconduct. In an even more telling moment, the one speciously published video, the Army officer's video, that wasn't conducive to his audience's narrative generated the least amount of views and engagement on his channel. Okay, if you are a cop lover and you see something horrible, are you required to respond that says, "Oh, shit, that sucks"? Is that a new requirement? Again, a compelled speech. Cliff Overby has downloaded police misconduct and police brutality from Mark Stout's YouTube channel and re-uploaded it to his own. In an example of this, again, irrelevant, but posted a video to his channel titled "Arrested Outside a Courthouse Found Not Guilty," lawsuit link below. The other videos featured on his channel are similarly titled. The description under the video provided links to docket information and case documents that prove the truthfulness of the video's title. In the video, Mr. Mark Stout was arrested for protesting the arrest and trial of other protesters outside the courthouse. In the video, Ms. Stout was arrested for filming his arrest. The entirety of one of Mark Stout's published and copyrighted rap songs played throughout the entirety of the video. Mark Stout and Jacqueline Stout were tried and found not guilty on the grounds that their speech and conduct was clearly protected by the First Amendment. He filed a lawsuit on Jacqueline Stout's behalf regarding the incident. Okay, hold on. Did I just read that right? Mark Stout filed a lawsuit on Jacqueline Stout's behalf regarding the incident. Did you just admit to practicing law without a license? Because Mark Stout, I do know that you are a felon, and so you would not have you are a convicted felon of multiple counts, and you would never be able to get a law license, even if you were to somehow go to law school and pass the bar. You wouldn't be able to be an attorney anywhere in our states. So Mark Stout filed a lawsuit on Jacqueline Stout's behalf regarding the incident. Hold on, you guys. Let me look up Virginia law. Give me a second. Alright, you guys. Here we are. The Code of Virginia, practicing of law and all that stuff. Practicing of law. Let's look at the general definition. What is practice of law? Student internship program definition. Persons who hold a license or certificate to practice law under the laws of this Commonwealth and have paid the license tax prescribed by law may practice law in the Commonwealth. Any person authorized and practicing as counsel or attorney in any state or territory or in the D.C. may, for the purpose of attending to any case he may occasionally have, a licensee fee shall be chargeable against any such non-resident. Okay, nothing herein shall prohibit the limited practice of law by military legal assistance attorneys who are employed by a military program providing legal services to low-income military clients and their dependents pursuant to rules. Shall prohibit the limited practice of law under the supervision of a practicing attorney by third-year law students or persons who are in the final year of program of study as authorized by that statute. Okay. Nothing herein shall prohibit an employee of a state agency. None does not apply. Nothing herein shall prohibit designated non-attorney employees of DFS. Okay, no. Prohibit designated non-attorneys of a local Department of Social Services. No. Nothing herein shall prohibit designated non-attorney employees of a local department of social. No. Prohibit a non-attendance officer or local school division superintendent or his designee when acting as an attendance officer from completing, signing, and filing with the intake officer. Okay. Attorney means attorney at law. Okay, so that's who is allowed to practice and who is not. Okay. Practice of patent law, boring oath, penalty for practicing out without authority. Any person who practices law without being authorized or licensed shall be guilty of a Class 1 misdemeanor. A collection agency may refer debts to an attorney for collection. So that's an exception, kind of exception, but an attorney who is permitted by the creditor's authorization to enter into such representation agreements. So, by practicing law without a license, you are admitting to a Class 1 misdemeanor. Is that what you did, Mr. Stout? Okay, hold on. Let's go back. Okay, 61. Mark Stout filed a lawsuit on her behalf regarding the incident. Were there any exceptions for family members that you can file on behalf of family members? Because I didn't read that. Okay. So they cannot no longer expound upon that case or the outcome of it. That's definitely going to get to be added to my list of stuff to look at. He filed a lawsuit on his own behalf regarding the incident, which is still pending in federal district court. Okay. He downloaded the video from Mark Stout's channel, deprived the video of its judicial and exonerating elements, and uploaded the deceptively hollowed out version to Cliff Overby's channel. Okay, so let me make something clear to you. Fair use, another one of those factors of fair use, is did you use the thing in its entirety or only to prove the point that you want to make? To put your own spin on it. That's exactly the definition of fair use. That's the exact definition of it. Okay? Cliff Overby titled the video something to the effect of "Stupid Monkey Tries to Climb Courthouse." Now, if he were not white, then this could be considered racist. But because it's a white guy, this isn't racist. But the rest of anything else he says is racist. I mean, okay. He provided e-begging links in the video's description, asked viewers for handouts in the form of donations and tips. His voiceover to the video was something to the effect of "Legalize drugs as a troublemaker, agitator, and instigator. He uses too much drugs and does dumb stuff." He was sober in the video. Hence his irritability and abrasive nature. You can't film cops. Filming cops is obstruction. You can't protest against cops out front of their own courthouse. People who get their rights violated deserve it, and legalized drugs should have been tased or shot. I haven't seen this video, so I don't know if he said this stuff, but nothing in there is worthy of a lawsuit. Due to his tonal inflection that he developed from being raised in the streets, and due to Mark Stout's rap persona, his audience posted comments about Mark Stout to the video, calling Mark Stout a wig. Okay. Posted comments to the video to the effect of, "I wish that cop would have introduced his constitutional rights to Sparky the Taser." Sparky the Taser is a very popular endearment embellished by Cliff Overby and Cliff Overby's audience. The endearment refers to a police officer's deployment of a taser or stun gun on an individual. Holy cow, we are already at 30 minutes, you guys. And we are only at page 10 of this stupidity. Okay, we're going to try to get through this section before we call this one a video. Cliff Overby's audience posted comments to the video that expressed the audience's desire to murder him, commit acts of rape and revenge against Mark Stout and Mark Stout's family. Again, I don't know. They struck the video from his channel because YouTube determined that he stole the music contained in the video from Mark Stout. And I've seen this in Legalize drugs videos, he puts his crappy music in the background, and so the only way to actually use any of it is to completely mute the music, the audio, but then you don't get the stupidity that comes out of his mouth, and that's why I won't use his crap, because he just says stupid stuff anyway. It's not worthy of being republished, and I cannot see a good fair use argument for using the music. You're not unless you're commenting on the music, you can't use the music. Unless you are turning that music into its own musical piece. I don't see you surviving a copyright strike. But again, not relevant to this lawsuit. Irrelevant. That's not what you are suing him for. So, relevance to this case. There is none. And you'll see he talks about it like 5 other times later, like it has anything to do with anything. We're only 10 pages into this, you guys. We're on page 11 here. I've got to get back to work. Stop recording. This lawsuit is stupid. So far, all I've read is a bunch of irrelevance crap. And this next section, his audience, how is this relevant to your case? And actually, I think it'll hurt your case, because if his audience, you know what, we'll talk about that in the next video, I think. Why I think his audience will actually hurt your case of defamation. We shall talk about that when we get to the cause of action and stuff. So there we go, you guys. What do you think? Is Schrodinger's cat right here? Is legalized drugs? Is it somewhere in the middle? What do you think of the stupidity in this lawsuit, the irrelevance? Did he practice law by filing on somebody else's behalf? If you prepared legal documents, that would require full analysis and looking at case law. Has Virginia case law found that preparing documents for somebody else to file, is that practicing law in Virginia? I don't know the answer to that. He said he filed it on her behalf. So that is a clear indication of practicing without a license. Is just preparing her documents, is that practicing law in Virginia? I don't know. I think his lawsuit here actually does open him up to prosecution, which I find would be hilarious, because people who pretend to be attorneys for other people when they're not, I think that's stupid. I'm not going to try to, I don't provide you legal advice. I don't try to do your paperwork for you. I'll read it and I'll criticize it. I'll laugh at it. Or I'll agree with you. But I'm not going to try to prepare it for you. I'm not going to file it for you. That's not me. That's not. I would go to jail for that, or at least I would be charged with that. So I'm not an attorney. I don't pretend to be one. I've always been open about that. What do you guys think? Let me know in the comments below. Have a great day.